Today we're going to go over estate planning. We're going to talk about wills, valid wills in Florida, about amending or revoking a will, which also includes a little bit about divorce, what happens if there's a lost or destroyed will, the anti-lapse statute, and what to do if there's mistakes in your will, and then finally, what about changes and the penalty clauses. Estate planning is basically the managing and passing of your assets through the preparation of documents and the retitling of those assets to accomplish your goals. What I like to call it is integrated estate planning because, as I told you earlier, we work with asset protection and estate planning, and those two really go hand in hand to give you a comprehensive plan. To have one without the other would actually be incomplete. Now, everyone should have some sort of estate plan. That doesn't necessarily mean they need a will or they need a trust, but you should have some sort of plan in place as to what happens to your assets at death, who's going to control them, who's going to manage them, and how they're going to get passed. And also you want to make sure that with that estate plan that it covers in the event that you're incapacitated while you're alive, you want to make sure that your assets are properly titled and being managed for you. What is a will? A will is a document written by a person that we like to call the testator, and that designates where his or her assets will go at death. One common misconception that I find all the time is that people think that if you have a will, you're going to avoid probate. Probate is basically the court process that occurs at a person's death if they have any assets owned in their individual name without any designated beneficiary. People like to avoid that process. Having a will doesn't avoid that process. What it does is it effectively makes it easier and lets the person who created the will or the testator decide where their assets are going to go rather than how the state law is going to send it. For instance, Florida resident, you're married, you have children, but your spouse is not the mother of all your children, only some of them. So under Florida law, if you didn't have a will, which we call intestate succession, if you don't have a will, your spouse is only going to get half of those assets and your kids are going to get the rest. Now, maybe that's what you would have wanted to happen, but I find that most people really didn't want that because the effect of that is that the kids will require a court guardianship for handling that property or money, and then when they're 18, they go to the court and they get the money. And at 18, kids are generally still in high school. They're not ready for any sort of money or wealth. So that was probably not your plan. Wills can also contain a lot of different provisions. They can allow you to appoint a personal representative, which is also an executor. They can appoint guardians for your minor children, which is really critical. If your children are under the age of 18, you want to be the one who makes the decision as to who's going to actually be their guardian, both for physical custody and of their property. So without a will, you don't get to make that decision. In addition, in Florida, we have something called a separate writing for tangible personal property. Tangible personal property is jewelry, furniture, cars, clothes, collections, things of that nature. What they're allowed to do here, and in some other states it's allowed, is you can actually write something up in your own handwriting that designates where certain items go. And even if you change that list, you don't have to change your will. You just have to keep changing the list, destroy the old one, put the new one with the new will, sign it, date it, handwriting, it's fine. Just make sure you describe what you're giving, describe who you're giving it to. For instance, you may want to give your gold wedding band to your son or your daughter. You just write that in there, change it whenever you want. Whatever is the last one standing, that's the way it's going to go in probate. Also in your will, you can leave something called a specific bequest, where you can actually say you want to leave $10,000 to your nephew, or you want to leave your gold watch to your nephew. And then the rest of your assets always goes through what's called the residuary, where you might have seen this where it says, I leave the rest, residue, and remainder of my estate to my husband if he survives me, and if not, to my children per stirpes. Per stirpes, just so you know, is basically if your child dies before you and it says per stirpes, then the share that would have gone to the child then goes to the grandchildren or the children of that deceased child. How do you make a valid will? First thing you have to have is testamentary capacity, and you have to have testamentary intent. Capacity is basically anyone over 18 who is also mentally capacitated is able to create a will. Mental capacity is very interesting with a will. It's a little different with other stuff, but with a will, a person can actually not have mental capacity most of the time, but if they're having a lucid moment, they can actually execute a valid will. You want to keep in mind that while that is technically legal, if there's a situation where a person is most of the time lacking mental capacity and then all of a sudden they have a good moment, they execute a will, the chances of that will being contested or challenged are pretty high. So you don't really, as a practitioner, very careful about those things, but it doesn't mean that it wouldn't be legal if the person actually created a will during that time. In order to make sure that it has a good chance of being valid, probably would want to videotape the whole experience and read everything out loud, make sure you ask questions so that you can ascertain that the person actually knew what they were doing and what it said in the document. The other thing for capacity is the testator has to know what we call the objects of his bounty. That means they have to know who their family is, who would naturally inherit. Doesn't mean they have to actually leave them anything, but they have to understand who those people are. In most states, you can't disinherit a spouse. Actually, in all states, you can't disinherit a spouse. And the spouse would have to get, if you leave them nothing, then the spouse can do what's called an elective share, where they get 30%, it depends on each state, but approximately 30% of the decedent's gross estate. Now that means not just probate assets, but everything that the decedent owned, the spouse gets 30% of this. And that's an automatic right if they make that request to the court. Children, however, in most states do not have to be left anything. So it's important, however, to know who's my spouse, who's my children. You want to change how you leave things, that's fine, but if you don't understand who those people are, then that's considered not enough capacity to make a will. The other thing you want to actually make sure of is that you know you're signing a will. It may sound silly, but maybe you don't realize what the effect of the document you're creating is. So that's why it's proper. The first line of a will usually says, you know, I declare this to be my last will and testament. Very important. Also, you want to make sure that the will is signed properly, meaning that it's signed. First, the testator signs. The will should be dated, and then after the testator, you're going to have two witnesses. Every state has two witnesses. Nobody has more than two anymore. If you want to go the extra mile, you should have what's called a self-proving affidavit, which means that a separate piece of paper, or it's attached, but it's separate signing by the testator, again, by the witnesses, and then everybody's signatures are notarized. The idea behind that is that the notary and all the witnesses and the testator are basically saying that at the time the document was signed, the testator knew what he was signing, that it was the testator's signature, that everybody was in the same room at the same time and signed the document. The reason behind this is that if you have this self-proving affidavit, when it comes time to admit the will to court, there's no need for any of the witnesses to come forward to the courthouse and sign anything. If you don't have it, then the will still be valid, but a witness would have to come forward, and that's usually pretty difficult because you have to find the witnesses, then they have to get to the court. It makes it much more time-consuming and costly. You also want to be very careful as to who witnesses your will. You don't want beneficiaries of the will to witness, and you probably don't want the person named as the personal representative or executor to witness. It wouldn't necessarily invalidate a will if any of those people witnessed, but in many jurisdictions, if a beneficiary witnesses a will, then the beneficiary could lose whatever they were going to get under the will. Will would still be valid, but that interest would be gone. So you have to be very careful. So ideally you want to have disinterested witnesses for the will. Holographic wills are what's called handwritten wills. Written out in your own handwriting, they can actually be valid. In Florida, we allow them, but only if it meets all the other requirements of a will, meaning it's signed at the end by the testator, it's witnessed by 2 witnesses. Again, you don't need that notary. That would be a benefit, but it's not necessary, and the Florida court would admit the will as long as it did meet all the other formalities. Personally, I absolutely don't advise it. I think it's opening you up to a will contest, but I guess there are emergency situations where a person wants to write one out and there's no time to get to the lawyer. So they can be valid in the state of Florida. And interestingly enough, we also allow here if the testator signs their name with an X, as long as they were witnessed and they were of sound mind at the time, that can be admitted to court as well. How do you make changes in a will? If someone wants to make a change to an existing will, they can do 2 things. Number 1, they can do a codicil, or they can just create a new will. Codicil is like an amendment to the will. It has to be signed the same way with the same formality. Signing first has to, and then the 2 witnesses, and preferably the self-proving affidavit. The codicil will only change parts of a will. So you can actually say a provision, 1 or 2 provisions of the original will now be replaced by what you put in the codicil. Personally, I'm not a big fan of the codicil, and I always suggest to my clients that they do the whole will over again. The reason I think that is I think you run the risk of having conflicting interpretations between the provisions of the original will and the codicil. And then not only that, both documents have to be probated together. So it just makes more work and makes more complications. It might as well just go through the process of creating a whole new will. Generally, at the beginning of a will, it's going to say that all prior wills are revoked. And if it says that, then there's really no issue of whether or not there are any valid prior wills. If you don't have that, then you can physically destroy a will by tearing it up, shredding it, burning it, or any other method that will physically destroy the will. The problem is that if there's copies floating around on that will and nobody saw you destroy the will, they don't know that you meant to destroy the will. So you have to be very careful who you give your copies to. I don't usually advise my clients to give out copies to anyone for that reason, as well as what if you change your will, the people don't need to know what the last one said. So if you can't prove that the will was revoked, then it's possible that your intentions will not be followed because you might have revoked that will. But they can also admit a copy of the will and say you never revoked it. So it does have issue. That's why you always want to make sure any new will contains that statement. And if you are physically revoking a will, you need to make sure that somebody saw you do that. If there's any mistakes in the will, now that can manifest itself in a couple of ways. Number 1, was there a mistake in maybe the names were wrong, maybe the bequests were wrong. You always want to read that will before you sign it and make sure that it's the way you want it, and have the attorney explain it to you if you don't understand the language. If you catch a mistake before you die, then you got to run to the attorney and make sure they correct everything and you re-execute it properly. Don't cross anything out, because if you cross it out, you run the risk of invalidating the will. I've had many clients come to me and say, oh, here are the changes I want to make, and they've written all over the original will. I tell them not to do that, because if you do that, you're running a risk of that will being considered void. So don't do that. If there are mistakes found after your death, then it's really going to depend on what the mistakes are as to whether they're handled easily or there's a will contest. But it can happen that there's a will contest because of that. There are times when a person's will is actually, the original is actually lost. I personally had a situation recently where Nobody could find the original, but I had a copy in my file. And what happened was one of the witnesses who happened to work in the office made it easy, had to go to the court and to swear in as to the will, that they were there, that the person signed the will, that they knew what they were doing at the time. That happened to have been a fairly easy situation. It also worked out because the will itself was what we call a pour-over will, which means that all it said was all the assets of the probate estate went into the living trust that the person had created. In those types of situations, it's highly unlikely that they changed that will because the beneficiary of the will is going to be the living trust. So that happened to have been an easy situation. It's not always that easy. Sometimes you can't find the witnesses and you really don't have anybody to go to court, and it becomes a very big problem. So it's critical you keep that will in a safe and dry place and you let somebody know where it is so that this should never happen. In Florida, if you can't find that will, then there's a presumption that it's destroyed, and the only way around that is to present evidence that says that it wasn't intended to be destroyed. And it's a court process. It can be lengthy. It may or may not work out in the way you want. And if the court doesn't agree with you, then it's going to probate as if the person died without a will. Will deaths are unfortunately not uncommon. In Florida, well, there's such a thing as a no contest clause or an inter rerum clause, where it'll say that if any beneficiary contests the will, they'll get nothing. In Florida, that's not an enforceable provision. That's not to say you can't put it in and scare people off, but it's actually technically not enforceable. So if somebody did any sort of research or spoke to any attorney, they'd know that it's really not enforceable. Will contests can be very costly. They can take years, and in the end, it usually ends up settling out, and it just costs everybody a lot of time, aggravation, and incredible emotional harm. The only person that can contest your will is somebody that has what we call standing. And standing means that person was either a natural heir of the decedent or they were named in an earlier will and are not named in the new will. For instance, a girlfriend who is never named in a will can't contest the will. However, if she was named in the will and got all the money, the kids can actually contest the will and say that she shouldn't have received the money, that for whatever reason, the will is not valid. And some of those reasons might be undue influence, duress, fraud, insane delusion. There's a bunch of ways to contest the will. Undue influence is where there's a person who's actually in a position to unduly influence the person making the will, and that person then ends up receiving more under the will than they would have gotten. For instance, the girlfriend, if she's living in and she whispers in the guy's ear that his children are good-for-nothing children and she should get everything under the will, then she really is in a position to unduly influence, and that influence got her more than she should have gotten. So the children can contest under undue influence. That doesn't mean that they'd win, but they would be able to contest. They'd have a decent case to try. Also, where there's a caregiver situation and the caregiver is taking care of an elderly person, the children could contest the will if the caregiver is given money under the will. You always want to be wary of contesting because it does cost a lot of money and it does take a lot of time before the estate can be distributed, and it could deplete all the estate assets. Another way to contest a will is called duress. That's if, let's say, a beneficiary threatens the testator, and because of those threats, the testator changes their will. That would be considered duress. Let's say a situation where the testator needs some serious medication or needs an organ donation, and the person who's positioned to give them what they need says, okay, I'll do it, but only if you change your will and leave me everything under your will, or leave me an excessive amount under the will. That would be potentially duress. Another one is an insane delusion. This is less common, but this is where the person who's creating the will, the testator, is under some sort of false belief that actually it's completely invalid. For instance, they think their kid's a vampire and therefore they're not leaving them anything. then that could be a will contest by the kid who's clearly not going to be a vampire. Say that's what induced him to make the will that way, and that's just not true. Another way is fraud. If somebody lies to you and tells you something that's not true, or sticks a will under your stack of papers and you think you're signing something else, those are instances of fraud. And if fraud can be proved, then the will would be potentially invalid. Also, if, let's say, the testator didn't actually sign the will, if it can be proven that the will is a forgery, that's going to be thrown out. And finally, if the way the will was signed was not done correctly, for instance, the testator signed after the witnesses, then theoretically that could be a will contest and the will can be thrown out. There's something called an anti-lapse statute. Lapsed gifts are those that are in a will. You leave something to somebody in a will and that person dies before you. So that therefore there's no beneficiary there to take that gift. So what happens? Well, if it's properly drafted, then the will would say, okay, if somebody dies before you, then this is who would get it. If the will is not properly drafted, then the lapse statute would say the anti-lapse statute would say who is the beneficiary, the intended beneficiary. And in general, if the intended beneficiary was a lineal descendant, meaning a child, grandchild, etc., of the testator, then their children would take the gift instead. But if the intended beneficiary was not a close relative like that, then the gift would lapse and go into the residuary, which is the catch-all clause at the end of the will. When do you want to update your will? If you get married or if you get divorced, it's very important to revisit the will. You usually want to update it at that point. What you should know is if your will names your spouse as a beneficiary and names your spouse as personal representative, the minute you get divorced, it's treated as if that spouse died before you. So they can't inherit under your will. They cannot serve as personal representative. If you have a good relationship and you want it to be that they still get under your will and they still can serve as personal representative, I would highly recommend changing the will after the divorce and writing in former spouse and putting that in that you specifically want them to continue to benefit under the will. But if not, it's as if they died before you and the contingency plan in the will kicks in. So if you had it in there that if your spouse dies before you, then your children get your assets, then that's what's going to happen. But it's very important to revisit the concept. Then you've got the concept of you created a will and now you get married. Well, if you created the will and then you get married, the spouse is treated as if you completely forgot about them. It's called a pre-terminated spouse. And that spouse is going to take as if there were no will in the first place. So in the state of Florida, as long as you had no children, or your children are only with the spouse, then that spouse is going to get everything under the will and everything else you wrote before is not going to happen. So unless that's your intention, you'd want to make sure to change it and do a new will after you got married. If you have children, a new child, that could require you to change your will if your will is not done properly. If your will was done properly, then it would account for any new children. However, if let's say a new child is a special needs child, you'd probably want to change how you did your will. If you move from one state to another state, you definitely want to change your documents for several reasons. One, you never want your old state to claim you as a resident, just in case that state has inheritance taxes. Also, there might be provisions that were valid in one state but are not valid in others, and there might be some benefits to the new state that you didn't have in the old state. For instance, we talked earlier about that being able to write out your list of who gets your tangible personal property. That's not available in every state. So you want to make sure to visit an attorney when you move and have them change all your documents so that there's no issue of them being valid in that state that you've just moved to. You probably should have your estate plan looked at every year. It doesn't mean you have to make changes, but you want to keep up with it. Make sure there's no changes in the law or changes in your family situation. So I would recommend every year, 2 years, 3 years, just visit your attorney, make sure everything is up to date.